Showtime after this.
You are watching Verdict Media TV, and I am breaking down the system with
Judge Joe Brown.
And our word for today is bond motion.
Bond hearing. In other words, the Constitution says a person is entitled to a bond. The bond is not to be excessive. The bond is to be set based on the determination of the defendant's circumstances, his financial background, his connections to a community, his likelihood or non-likelihood of flight. In other words, the bond is to be set in an amount or under such circumstances that will ensure that the defendant is likely to continue to appear before the court in question until the charges are disposed of. Sometimes a person can have a background and be of such circumstances as indicates that his or her promise to return for the completion of the proceedings is sufficient. That's called a recognizance bond. In some places it's called ROR, released on own recognizance. It is basically a promise, I'll be back. Now, there are other bonds. Some places have what's known as a cash bond. In other words, if it's for $5,000 cash bond, somebody puts up $5,000 in cash. If it's a surety bond, a bonding company puts up a $5,000 surety bond. The bonding company is entitled to charge 10%, and in some states from 25 to 50 to 75, maybe 100, it depends upon the situation, processing fee. So the bonding company puts up $5,000. The family paid the bonding company $500. The defendant does not get that $500 back. That goes to the bonding company for them risking their financial circumstances on the assurance that if the defendant appears in court, then they won't be held on a forfeiture of the $5,000 bond that they have stood as surety for before the clerk of the court or before the court itself, depending upon the local circumstances. If the defendant does not appear, then a conditional forfeiture will be taken and a final forfeiture date will be set. The bonding company will then have a right under American law to go forth armed with a copy of the warrant in any state and forcibly and in an armed fashion take the defendant in custody and bring the defendant back before the court for the completion of the proceedings. A bonding company who finds a recalcitrant defendant who is not cooperative may take that defendant into custody and surrender them to the court or to the sheriff and have them held pending a bond review. But in any event, what you have here is a bond that's set. The bond can be set based on a formal request in writing. It can be set because some jurisdictions have certain judicial officers who are authorized or required to set bonds in a certain situation. Generally, in most jurisdictions, any judge above a certain level can set a bond on any defendant taken into custody. So ordinarily, they may have as a routine matter, a lower court judge sets the bonds on those defendants who are brought to his or her attention. You may have a judicial officer, a magistrate who sets the bonds on a routine basis based on reports from pretrial release relative to defendants who are brought to his or her attention when they first get brought in and they are locked up. Or you may have it where a lawyer is of long acquaintance with a certain judge and may call the judge up at 4 a.m. in the morning. John, this is Robert. We've got a client. He's got a background that's a pretty good one. We need a bond set for him. He's charged with so-and-so. Well, what do you know about him? Well, I've dealt with some of his people before. They seem to be reliable. I've known this kid for a number of years. Well, why does that make a difference? Well, the lawyer is an officer of the court, and as such, he has a duty to report to the court truthfully. So the lawyer in question, having had long dealings with this judge, either in practice from years in the past or as an attorney before this judge, has set up a track record of reliability and has been honest in his presentations to the court. And the court says, well, what do you think the bond ought to be? So, well, this is a so-and-so case. We're suggesting, Your Honor, $2,500. And the judge says, no, Robert, are we going to get in a mess because there's a whole lot of publicity on this thing? Don't put me out here on a limb. So, well, there are some people interested, but you would ordinarily qualify for an ROR, but we think $2,500 would satisfy.
You've been watching Verdict Media TV, where the jury is out and the verdict is in. Follow me as I take you on a journey from the streets to the high seas, interviewing and connecting with some of the world's most influential and powerful people. We will also be speaking on various topics as it pertains to the criminal justice system. So please subscribe, like, follow us on Instagram, Facebook, and also Twitter. Also, support us by visiting our store. Click the link in below. Thanks for your support.